Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore two questions involving preemption rights, a topic in business law under FLK1. Let's dive in. A shareholder owns 10% of the ordinary shares in a private company. The company has only one class of ordinary shares and has adopted the standard model articles. The directors plan to issue new ordinary shares for cash to an outside investor. The new shares will represent 20% of the company's enlarged share capital. The shareholder is informed that the new shares will not be offered to existing members before the allotment. Concerned about dilution of his voting power and economic interest, the shareholder seeks legal advice. Which of the following best describes the legal position? A. The shareholder has no protection because statutory preemption rights apply only to public companies. B. The shareholder has a contractual right under the model articles to receive a proportionate allocation of the new shares. C. The shareholder can block the allotment by voting against the necessary special resolution. D. The shareholder is protected by statutory preemption rights requiring the company to offer him a proportionate share of the new shares first. E. The shareholder can require unanimous member approval because the allotment affects his class rights. The best answer is D. Under the Companies Act 2006, when a company issues new equity securities for cash, existing shareholders generally have statutory preemption rights. This means the company must first offer the new shares to existing shareholders in proportion to their current holdings before offering them to outsiders. In this scenario, as there is no indication that the shareholders have passed a special resolution disapplying preemption rights, the 10% shareholder is entitled to be offered approximately 10% of the new shares before they are offered to the institutional investor. Question 2. A private company has one class of ordinary shares and has adopted the unamended model articles. The directors have authority to allot shares. To acquire a valuable software business, the company agrees to issue new ordinary shares to the seller as consideration for the transfer of the business. No cash will be paid by the seller. The new shares will represent 15% of the company's enlarged share capital. A minority shareholder objects, arguing that he should first be offered a proportionate share of the new shares to avoid dilution of his voting rights. Which of the following best describes the legal position? A. The shareholder is protected by statutory preemption rights because all allotments of ordinary shares must first be offered to existing shareholders. B. The shareholder is protected by statutory preemption rights because the allotment will dilute his voting power. C. The shareholder is not protected by statutory preemption rights because the shares are being issued for non-cash consideration. D. The allotment cannot proceed unless it is approved unanimously by all existing shareholders because it affects their economic interests. E. The shareholder is entitled to require the company to buy his shares at fair value if he objects to the allotment. The best answer is C. Statutory preemption rights under the Companies Act 2006 generally apply only where equity securities are allotted for cash. Here, the company is issuing shares in exchange for a software business, which is non-cash consideration. As a result, the statutory preemption regime does not apply. The shareholder may suffer dilution, but dilution alone does not trigger statutory preemption rights where the allotment is for non-cash consideration. This table summarizes the differences of the above two cases. In case 1, the company is selling new shares to an outside investor for money. Because this dilutes existing shareholders, preemption rights apply by law. The company must offer the shares to existing owners first, unless the shareholders vote to waive this right. In case 2, the company is using new shares as currency to buy a software business. Because it is a non-cash deal, preemption rights do not apply. The company can give the shares directly to the seller, as long as the directors have the general authority to issue shares. The main takeaway is that if a company issues shares for cash, existing owners have the right of first refusal to protect themselves from dilution. If it issues shares for assets, that protection doesn't apply, allowing the company to close the deal quickly. Targeting a pass in the upcoming SQE1? Knowing the law is one thing, navigating the SQE's tricky logic is another. Our question bank bridges that gap. We offer over 600 rigorous MCQs across FLK1 and FLK2, specifically designed to mirror the actual exam's difficulty. No surprises on exam day, just preparation. Test the quality of our questions today and see the difference for yourself. Start your free mini-mock by scanning the QR code here. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.